This podcast is brought to you by Firehouse Subs, the firefighter-founded hot sub chain with a passion for hearty and flavorful food, heartfelt service, and public safety. Ready for your next mission? Firehouse Subs is offering firefighters the opportunity to continue serving after service, now as restaurant owners. Learn more at firehousesubsfranchising.com.
Welcome, everybody, to Fire Service Court Video. We used to be Fire Service Court Radio, and now we're on video because we're modern technology. With us is the Honorable John Murphy, the head of CHIP Comstock, big shiny, there you go, myself, Brad Pinsky, and we are missing in action, but he's somewhere trying to get on, Kurt Verone. And today, so when we know our monthly shows coming up, we're like, okay, what's hot? What's the topic? What do we think people want to hear? And I'm very humbled this month because the unanimous consensus is we should talk about a case called Ball versus the state of New York, which happens to be my case. And obviously very humbled. I will tell everybody about it. And really the point of this case is the ramifications across the country. This is not just a New York case. So let's see if I can do this some justice. So an individual, Justin Ball, was charged by the New York State Department of Health, a state administrative agency, who has the power to impose fines. Those are important issues. And they charged him with negligence, malpractice, a mental or physical assault. And I bring those up because those are what's known as common law causes of action. They exist out there just because they exist. I'm not totally sure how to explain common law causes in the simple form.
They've been around a long time. Before the code.
And before the U.S. Constitution, right, is really the issue. And so I didn't think I had an amazing chance to win this case before the State Department of Health, because I think it's a very biased agency like every other agency. They have their own judges, and everyone should understand the problem with administrative agencies. They have their own judges. Assuming they're even neutral, they have a very low burden of proof. The state has to basically have a very small percentage of the facts in its favor. It is not hard for them to meet their very, very, very low burden of proof. And there are no rules of evidence. The state can simply get up and say, oh, I'm the investigator. I spoke to that guy and that guy spoke to that guy. And he said that 4 people down the road, well, they all said something and I'm guilty, right? And so hearsay and everything else is admissible. There's no rules of evidence, very few. So it's very difficult to win in an administrative agency. And I know Chip does, and I do work before administrative agencies, and it's very difficult to win.
Our last
the other thing too.
Brad's and my last joint effort in administrative agency did not go particularly well.
Did not go well. When you get a biased judge, that's unfortunately what happens. So
the other problem I run into too is they're not very forthcoming in disclosure of material that they got. So when you're representing a client on an administrative law issue, especially paramedics or EMTs, you go, what's the complaint? I need the evidence so I can defend my client. They go, you need to file a public records request to get the information. You never get it until like 2 or 3 months later. So they delay.
Well, and I went to a hearing once. It wasn't with EMS. It was on an insurance matter, and they literally ambushed me and my client, which gave me a basis for a constitutional appeal because I'm like, you've given me. They literally threw on charges and theories at the hearing that had never been disclosed. So I'm like, okay, this is great. Now I have a good constitutional argument. But, the other thing you got to, the judges are not elected, right? Most of them are appointed. And they're appointed. Why? Because they're going to be favorable to the entity that appointed them. That's just the way
and
it
they're
goes.
Not all lawyers. Not all administrative law judges are actually real lawyers. Some are not or have zero trial experience.
There you go.
Right?
Yeah.
So for the reasons John, Chip, and I are saying, these are very much stacked against you. So what does it do for the paramedics, for EMTs, for doctors, for anybody before any administrative agency? It makes it makes it so easy for a state to take away your livelihood, right? Whether it's your EMT cert or paramedic or you're a doctor, it just makes it too easy and we have no defense. So I had this insane idea after reading a 2024 U.S. Supreme Court case. And what that case held, SEC versus Jarkessi, held that in a federal agency, and in this case, the Securities and Exchange Commissions went after a person and fined him $300,000 for fraud. So they have a fine and they have fraud, which is a common law cause of action that existed long before the U.S. Constitution, fraud. So the U.S. Supreme Court said, you know what? We're not going to allow this to go through the federal agency. And they said that the 7th Amendment to the United States Constitution, which gives people the right to a jury trial in civil matters, right, where you're being sued for money, not criminal matters, that's already been applied to the states. But they said the 7th Amendment to the U.S. Constitution for a federal agency has to give you a jury trial when two things are present. One, they're trying to or are able to fine you. Whether they impose the fine or not doesn't matter. It's merely available. And the second is the issue we've been talking about, which is, and there's a common law cause of action that they're using to go after them. So again, in the Ball case, they're using negligence, malpractice, basic things, basic causes of action. So the U.S. Supreme Court said, well, listen, so when a federal agency, when they're seeking a fine under a common law cause of action like fraud, you have the right to a jury trial. And so they took it out of the hands of the Securities and Exchange Commission, and the court, U.S. Supreme Court, admitted therein that going before an administrative agency offers much less protection. So there should be a right to a jury trial in certain instances. So where were we from here? I'm like, great. So let's do that in state court. Except, and people don't realize this, and it's a little hard to explain, but not all of the federal constitutional protections apply to the states through the 14th Amendment. In other words, they are federal protections, but the state could still violate some of your rights. Take New York State, who was found twice by the U.S. Supreme Court to have violated the Second Amendment rights, the right to bear arms. And shockingly, we all talk about, we have the right to bear arms, except it was only in 2010 when in a case called McDonald, the U.S. Supreme Court, yay, there's Kurt. It was only in 2010 when the U.S. Supreme Court actually held that the Second Amendment applies to the states so that the states cannot violate your Second Amendment rights. So what was the challenge we faced in Ball v. State? The 7th Amendment does not yet apply to the states. It's good for federal agencies, but it doesn't apply to states yet. So there's a couple of thousand cases, I'm not exaggerating, and 2 or 3 U.S. Supreme Court cases, the latest from 1916, 1916, that says, no, the 7th Amendment does not apply to the states. But what I noticed is that starting in 2010 or so, the U.S. Supreme Court is shifting to Justice Rehnquist's view, and now deceased, but his view was the 14th Amendment was created to apply all the federal government's rights to the states so that the states cannot violate your federal constitutional rights. And I believe the U.S. Supreme Court is shifting their view. But before you get to the U.S. Supreme Court, you got to get to the U.S. Supreme Court. So what the discussion we're having today, again, this case, Ball versus State of New York, here's what the court held. This just came out 2 weeks ago. Almost everyone on this panel is going to get some credit in some way because they had some input into this that enlightened my thinking. The hero to this case, before I take any credit, is the judge. If all of you want to read it, you should. The judge wrote the most brilliant, historical-filled decision there was, 26 some odd pages. I argued it. I had the idea, but man, I couldn't have done anything like this judge did. He set himself up to not be overturned. So here's what the judge said. The judge said, 1, in New York State, he applied the 7th Amendment, the right to a jury trial in a civil matter. He said now applies to the states. He did not say applies to New York State. It applies to all states. Now, he's a local judge in New York. He can't have any effect other than persuasive on any other state. But everyone should understand this holding could be, and many of us may try to push it soon in our own cases, this holding is a national holding. So he holds, one, the Seventh Amendment applies to the state of New York, and then looks at the Department of Health specifically and says, so just like a federal agency, SEC in the Jarkessi case, has to give a jury trial and administrative hearings or proceedings, he said the Department of Health is seeking a fine, and it's available to them, and they're using common law causes of action. So the judge says, under those two circumstances, the Seventh Amendment applies. So where are we here? Well, ending my kind of presentation part, turning this over to the panel, the state has not yet appealed. They have another 15 or 20 some odd days to file a notice that they intend to appeal. Then they'll have 6 months to perfect the appeal. Everyone's curious whether they were going to appeal or not, right? If they don't appeal, then the court stays as a lower court decision. But on the other hand, I've got 3 or 4 other cases that I'm going to use it for. I just had a very favorable, and we'll talk about ramifications in a second, but I just had a very favorable discussion where somebody threatened one of my clients, and I said, read this decision. You owe me a jury trial, Mr. Village. You can't punish my clients. And they agreed that, okay, well, we'll find a different route. So that's where we are. This could go to the United States Supreme Court. If the Attorney General appeals from here, it would go to the appellate division. If the appellate division splits, it definitely goes to the state's highest court. If the appellate division finds in my favor, then of course it will probably go to state's highest court. And if it's unanimous against me at the appellate division, we will ask for it to go to the Court of Appeals. It is going to be very tough, as this judge wrote the decision, to disagree with him. He seemed to pick off every possible point, and the state did a tremendous job in going through the entire history, and he filled their argument with bullet holes. So from here, John, Chip, and Kurt, I stand humbled, sit humbled that we're even discussing this today. I turn it over to you guys. What does the case do for the average firefighter and paramedic?
May not do anything for the average to good firefighter, paramedic, but the ones that get in trouble, it's going to be a big deal. What we're talking about is our client who, for good, bad, or indifferent, find themselves in front of a state administrative agency. And this is going to turn a lot of states' practices on their head.
Yeah, I have this. I'm going to challenge it for our Division of Human Rights, which is our local EEOC. Interestingly, the EEOC gives you a jury trial, right, as a federal agency, but many states' human rights, agencies do not give you a jury trial. But they open at least New York does. I can't tell you about other states, but at least New York opens a concurrent file. They give you a federal agency ID for the EEOC, and they give you a state, right? So I think that is the best case possible, way better than the DOH case, to say the Seventh Amendment applies, because the EEOC would have to give you a jury trial, right? And now the state's not, and there's a parallel, case going on. So I think this will go to Division of Human Rights. Kurt had asked a while ago, could this affect OSHA? Typically not. The exception to the Seventh Amendment is it's got to be based on, as Chip said earlier, a right that existed prior to the Constitution, right? Negligence, malpractice, some sort of cause of action.
Well, I think that's the challenge that I think I foresee is the argument that the cause of action is not a common law cause of action. It's an administrative provision, right? That you violated these code sections, and your judge understood that the code sections that are being cited were analogous to a common law, right? That he's saying, you're saying this, but it's really fraud. It's really negligence. And so I think that if somebody's going to fight it, they're going to say, we're not looking at the common law. We're looking at these statutory provisions. And that may be one of the tough parts. But the other thing is, wasn't there also discussion in your case about the property interest and taking away a property interest due process issue? I mean, with a jury having title to a jury trial, one of the things you had said to me when we discussed it, well, how would the administrative agencies fight this if this were changed? I said, well, do away with the fine, right? You just or do away with do away with a fine, and then it's a license suspension, and you might not be entitled to that. But as I read, it's like I think that still might apply if somebody has a property interest in their certification that can't be taken away. Their certification can't be taken away without a hearing. It's not, we're not like, employment at will. So what is your take on that? I mean, do you think that the property interest alone would give somebody the right to a jury?
So first, Kurt gets the credit for the due process property argument, the winning argument. See, when people hire one of us, they get all four of us. They just don't know it, right? Because we'll all talk about stuff, whether it's at a wedding over a drink or, whatever. But, hire one, you get all four. So that's not a bad, or maybe it is, I don't know, pitch. But the Seventh Amendment says that the issue in controversy has to be over $20. Now, maybe that was a lot of money in 1787 or 1776, but I believe, and I'm sure there are cases on this, so we could get a fair answer. I believe that losing, whether it's a fine, a penalty, or losing a license, probably places the issue in controversy at $20 or more, right? You lose your ability to earn a living, perhaps. Again, I'm sure there are cases on this, but my first guess is it would qualify.
Well, you know where it might come in. I've got some folks that have done some work in Florida, and Florida has kind of it's an interesting dynamic on their EMS certifications. But each fire department here in Rhode Island, each fire department has their own medical director, and usually it's the same person that handles all of them. But the bottom line is, you have the right to have your own medical director. In Florida, it's assigned by the county. The county hires a doctor to serve as the medical director. And whether you're part of the county fire department and this is where cities get in trouble, you have a city fire department that's within the county, but the right to practice is at that county medical director. And again, some of my clients, my good friends down there, have run into a situation where the county medical director says, I am not going to allow you to practice. And that person, because of the job requirements of their municipality, they are terminated. And they have no hearing. It's one of those things where there is no hearing, there's no right to it. So this may kind of open the door, and I hope my friends from Florida that have, the union folks in particular that are concerned about this may look at that and say, you know what, this may give us a window. Now, admittedly, the administrative things, the things that you've got to do this, you've got to do that, the administrative things that don't arise to like negligence or some of the other common law types of things might not be impacted. But
Kurt, just as an FYI, as we're talking, there's a case out of the Northern District of Ohio on that very issue in which the federal judge said that if the municipality blindly following the medical director's decision without a hearing is a violation of due process.
Yeah, I argue that, and I mentioned that, but apparently that's been litigated and not to the firefighters' advantage. So that's not
didn't hire the right lawyers.
Yeah, I don't mean to hijack the discussion, but I think what Brad was talking about here. There's another issue that Brad and I talked about, and it has to do with what does a fire department, what does an administrative agency do now to clean up the due process issues that Brad has raised. And one thing I threw out, and Brad, he wasn't too keen on it, but one of the things was whether or not the administrative agency could issue whatever the penalty is, but then give the firefighter the right to a jury trial, but it would have to be a de novo process. So the appeal, basically, we're going to fine you, but you can appeal. And then at that point, you appeal it to a court and the court gives you the jury trial, but it's got to be de novo. It can't be the court reviewing the administrative decision. It's got to be de novo.
And I guess what is the point of that, right? I mean, you're just adding an
14th Amendment.
Well, I guess. No, I know. I mean, what's the point of having the original administrative hearing?
Well,
You're satisfied, I guess you'd say,
it's
well,
almost like a probable cause finding.
yeah. Well,
Yeah.
or I'm happy with the outcome, right? They gave me a slap on the wrist. I'll take that and move on. And I want to spend the time or effort to appeal to a jury. And that might make economic and time sense for a client. But, if you've got, if they're saying we want to take away your client's license or right to practice or your certification, got nothing to lose by appealing it at that point.
Yeah, but the question becomes, is the appeal an appellate review of the administrative decision, or is it a de novo hearing with a jury trial?
Well, based on Brad's case,
yeah,
it's got to be a de novo hearing.
Yeah, I think so.
Because otherwise you're denying me the right to a trial by jury. That's the whole point.
Yeah, we're all familiar with the judicial review of an administrative decision, which is unless the administrative agency really screwed it up, it's going to be a rubber stamp.
Yeah, and that's, I guess we should point, we haven't discussed that fact, but that's exactly how it does work. When you go to you get hammered by the administrative judge, and then you get to appeal that to a trial court for a review. And for the most part, unless the decision was unconstitutional or completely, off the rails, they are going to rubber stamp it.
Yeah. And that's the problem. We really have no way to protect the living of people who are EMTs, paramedics, firefighters. But again, this is going to go to doctors, et cetera. I do have a question for you, which is this. So I just used this against a municipality who said, we're going to suspend you, right? So not me, but suspend your client. And I sent him the decision and I said, I think you got to give me a jury trial. Now he's a super nice guy, the lawyer for this municipal entity. And so, first issue, he's like, well, we're not fining them. I said, yeah, but they're losing their pension, right? They're losing the ability to earn pension points and credit. I said, I think that's the value in controversy over $20. You're taking away a right. And his comment, for whatever it was, is, yeah, I agree. We're not going to do that. Let's see if we can find another way to resolve this, favorably to both of us. And because it's not just because, hey, the Seventh Amendment may apply to all disciplinary hearings for firefighters and everything else inside a municipality, village, city, fire district, whatever. But it's also because, as Chip's point, in his head, he's thinking, I could tie up some agencies in court for a very long time on this.
That would never be a proper purpose for an attorney is delay. But the practical effect of people not being prepared for jury trials, we'll say, unfortunately, slow things down.
Right. And it at least puts in the fear of, do you want to be the test case? Right? Because this is going to be a very long trail when you raise the issue, when attorneys raise the issue in any state. And it's going to be a very long journey, right? Potentially. And it's going to be a lot of work. For most lawyers don't do constitutional law. By the way, I got a C in con law in law school. I should definitely not be handling this case. But
did you disclose that to your client before you submitted the brief?
No. Sorry, Justin. So,
how did you get a C in con law? Jeez.
Yeah. It's,
there's another line of cases, and you got me thinking now. I got the $20 issue in the Seventh Amendment, or the due process issue. But there's a line of cases on public employee discipline, not just firefighter discipline, public employee discipline, that make reference to a term. And I don't necessarily agree with the term or the interpretation of the term, but this is the term. It's called a trivial deprivation. Okay, and the U.S. Supreme Court has said that up to a 2-day suspension without pay is a quote-unquote trivial deprivation, that while you may have some rights to some process, you don't have a full due process right to a full-blown hearing, no right to appeal. Basically, you've got to have some sort of summary proceeding where you're told what you did wrong and you're given the opportunity to explain or rebut. And that's really it. It's summary. Once that's complete, it's almost like the front end of a louder mill. Once that's complete, There's no right to appeal. There's no right to a de novo hearing. That's it. So I don't know how we square the two lines of due process where you have the $20 in controversy and the trivial deprivation line of cases.
I guess my thought is that, first of all, that the courts haven't been approached recently, as Brad pointed out, on that very issue, right? So they may have to square those out.
Yeah.
But it also seems to me that if I am getting back to the property interest issue, right? I think there you say taking away a person's ability to practice their employment for 2 days isn't that great. Brad's case, the person's license or certification is at risk, but they aren't going to be able to practice at all. So while maybe that 2-day suspension may be greater than $20, where I see, hey, we have a right to terminate your certification and to fine you up to $1,000. I think, it's all $20 is the threshold, but I think they'll look at these cases and say that it's something much greater than the trivial discipline.
Yeah, $20. I want to just
which would be worth $500 today. I just looked at an article.
Just kind of think this through with me. When I was a shift commander in Providence, I'm calling up people to work an overtime shift, which is in excess, obviously, by tenfold the $20 in controversy. So if I call firefighter Comstock and say, or Captain Comstock, I said, "Do you want to work tonight?" Does that now become a constitutional issue? Maybe I should have called Captain Pinsky for the overtime, but I give it to Captain Comstock, and now I've committed. Now I'm going to find myself in federal court over a due process violation where somebody has a right to a jury trial. I mean, how do we sort of be able to manage the organization without creating a due process?
Taking Brad's logic, what is the common law theory against?
That's what I was thinking. Right. There's
the
probably
common
no
law
law.
is breach of contract, I guess.
Could be. That's an interesting thought, because that is a civil remedy. Existed.
I mean, you're supposed to call. You're supposed to call in the order of seniority, and for whatever reason, I jump over somebody, or I can't reach you. You say your phone didn't ring. I say I called the number, and for whatever reason.
But do you have I'm just downplaying. We're going back and forth. Do you have is a contract between the union and the city? Is it? You're not a participant.
It's interesting. There is a CBA, but there still is an employment relationship,
Right.
And I don't get a paycheck from the union. It
unnecessarily hamstrings your ability to staff.
Yeah. So, and again, I think these are the problems that Brad has created for the world.
Thank you, everybody.
And these are the things I think that are going to have to get sorted out, because I can say, I recall, and one of my friends, quite a bit younger than me, but he was on the union executive board. But we had somebody who was pulling some shenanigans with substitution, and he came into my office to argue about substitutions, and it was like he was talking about like the constitutional right to substitute. I'm like, what are you talking about?
I don't think that existed. I think the Jarkessi case, so the 2024 U.S. Supreme Court case that held that the SEC has to give somebody a jury trial.
Yeah.
That obviously is landmark, right? That and even although the U.S. Supreme Court said this isn't a big difference from a prior opinion, but they took it anyway and put in some very nice language, which helped in my case. In fact, part of their language is what they'd said: the rights under the Seventh Amendment to a civil jury trial predate our Constitution. That's the only question on whether any amendment applies. Did the right predate the right to a jury trial? That's how Roe v. Wade argued there, saying this has always been a right, even though it's not in the Constitution, always been a right. So the questions there, and I'll get to my point in a second, but the SEC case, the Supreme Court said the Seventh Amendment right to a jury trial has always been a fundamental right. I don't know whether they were teeing that up for the states or not, but this is so new, even at the federal level. So my question is, look, we've got OSHA, But are there other federal agencies where, forget my case, where the U.S. Supreme Court case of Jarkessi comes in now to say you have a right to a jury trial? And I can't think OSHA, well, the EEOC already does it, right?
Not that have a big impact on us. I mean, I think there's probably agencies out there. I think some of the agricultural, the forestry rules and stuff are going to impact farmers and forests and so on. But EPA maybe. But in terms of the fire service, I think it's more going to be at the state level where we're dealing with the health department.
Yeah, and think of our nurses. So, John, you're a PA, right? You're licensed, not just certified. You're licensed as a physician's assistant. If you were to be disciplined, who's your disciplinary agency?
The Board of Medicine.
Board of Medicine. And the Board of Medicine is an agency who can take away your license without a jury trial, I presume.
Right. Yeah, without due process, basically. And so what I need to do is hire an attorney, not myself, one of you three, of course, and file an appeal. But as we said earlier, I think if the appeal process weighs against me and more favors the state, then my recourse is very limited.
How about attorneys? I mean, we mentioned, again, your license.
Right.
Committee malpractice are saying that you're providing substantial care, or you stole from clients who committed fraud, and you get a hearing before, in Ohio it's a 3-panel hearing, it goes to a 30-panel appeal, and then it goes to the Ohio Supreme Court, and there's no jury along the way at all.
No, I think you're right. I think that the due process is due. Like, I know that I read the bar, people who are just barred here, who are to read procedural hearings. And there's every step of the way, you're represented. That's the first thing. And then, as Chip said, there's an appeal process that goes all the way up to our Supreme Court, if you so choose to go that way. Most of the attorneys, because of the filings, are so egregious that, it's just so obvious that they need not to be an attorney for a period of time, if ever. And so the rulings are pretty much ironclad, and they basically never practice law again.
And one of the interesting things is going to be, and maybe we'll see it in my case, if the state, the Attorney General, has been ordered to grant us a jury trial. So here's the thing: how do you get one? There's no. So a normal for everybody's watching, which I think is my mother. Hi, Mom. So for everybody's watching, to get into court, you file some type of complaint or petition, right? That's how court proceedings are initiated in the civil world. How do you do this? It's really interesting. There is in New York, I'm not aware of any proceeding where the state, I guess they'd have to file a complaint. I mean, I'm not even sure what's coming next.
Well, or they file a complaint against. Brad and I've talked. I have a case that's very similar in facts to Brad's. I just got a hearing notice. I have had a complaint filed, and normally I'm thinking this way forward. I would literally file I think I'd file an answer to it and demand a jury in my answer. Right now, the burden's on them to do it. And the other thing that we talked about, there's a 2-part with 3 parts that Brad talked about right at the beginning. So I demand an answer, or I file a separate jury demand. I mean, that would be one of the interesting arguments. Have you waived under civil rules? Have you waived your jury demand? So I make a jury demand, and now we have 2 other issues. Once we establish a jury, one is we talk about the rules of evidence, and the other is who's our judge. Because as Brad says, administrative judge is not a common police court judge, and the rules of evidence have to be the rules of evidence, which don't really exist in administrative hearings. So there's a lot of different things that have to be addressed.
It's going to be very interesting to where we go from here. But kind of wrapping this up, we've done our, almost 40 some odd minutes, kind of on the wrapping this up part, not trying to cut anyone off, of course, but where will the fire service go from here, right? I mean, this really does affect EMTs, paramedics, but anyone, I think, even in front of a municipal entity, I think lawyers should try it. I think they should raise the issue. Notable, I also just became informed that the United States and New Zealand are two of the only countries who give jury trials in civil matters. This is apparently not a normal right. But despite what Hamilton and others said, other founders believe that we have the right to a jury trial, that we should not be hung by a king because the king says so, or have everything taken away because the king says, I want my taxes. And that's why we get a jury trial.
And there's some interesting historical discussions in your judge's opinion.
Everyone should read it. It's so interesting and having nothing to do with me. He nailed it.
One thing I do want to mention, though, that I think the right to a jury trial is a wonderful new development. But Brad, I also talked about you still have to evaluate, just as you would in any other case, whether you want to try it to a hearing officer or whether you want it tried to a jury. Now, you could go through his process, and I suppose at the end of the day, waive the jury and go right back to administrative hearing officer. Might be at that point pissed off about going through all this sort of procedural issues just to end up back in front of the administrative hearing officer. And I say it because there are cases, and I have a couple that I'm weighing right now, that the outcomes, the allegations might shock a juror. Even though I think when you dive into it and really dissect the case, you're going to find out that my client really didn't do anything wrong. And I'd rather have this explained to an administrative hearing officer who may be more sympathetic than a jury who just has that emotional, sympathetic reaction to maybe a negative patient outcome. So, I think that if you've been charged, you're in that process, even though the reaction might be, hey, I want a jury, I really think that's an initial decision that has to be made as to whether or not this is a case. And again, one that I have, it's similar to Brad's case. I think I do want a jury. I've already discussed that with the client, that I think we will have a better outcome in front of a jury when they are able to see all of the particular facts in this case.
Yeah, and that brings up one really important point we've kind of touched on, which is it's not just the jury. It's that you get the rules of evidence, you get discovery, you get, for example, in my case with Mr. Bowl, there's a video that's at issue. And everyone's like, oh, the video hangs them. Well, wait a minute. How do we know the video is authentic? How do we know that it hasn't been altered? How do we know part of it hasn't been cut out? How do we know anything? And that's what the rules of evidence in a court do. Nobody's more familiar with it than Chip. But when you're in court, you have to authenticate a document to make sure it's not been altered, that it is reliable, right? And so you get that. So in our case, look, I want to make sure, I don't know that they've ever preserved this video properly. I don't know that they could say, right, if the video's out, I win, right? Or he wins, because there's no evidence against him. But also you've got to present witnesses as opposed to what happens in an administrative hearing. Well, I'm the interviewer and I talked to him and he talked to her and this is what they said. And judge, here's double, triple hearsay and you should rely on it. How do you compete with that? Right? How do
the ability to cross-examine witnesses is critical.
And yet an administrative agency, you don't necessarily get to. You get to cross the investigator on what he thinks somebody else said, which would never be admissible in a real court. And yet we can lose our livelihoods by just somebody, having double hearsay, having a conversation with somebody else and telling the judge, this is what I say he said. Right? You have no ability to cross. You have no ability to test the proof. There's no right to expert witnesses. I mean, there's so many things wrong with administrative agencies and those hearings. I would just be happier, frankly, if there were all the rules of evidence and it was a real court. But it is very tough to win. And that's why I think this is so important. It's time for people to get a fair day in court and not just have their livelihood taken away from them for, without the right process. Well, with that said, this is not our normal show because normally we're around many more times if this is your first time seeing it. But I want to thank, the three of you for all the honors and kudos, and that I don't deserve, the judge deserves. But final statements, starting with our host, John.
Well, I was excited when you were telling me that you had this case, that you were successful in it. I know that when I do administrative hearings, I'm always figuring that I don't have a piss poor chance of winning this because of the evidence rules, and that's pretty much loaded against my client. And only by the grace of God and good arguing do we ever succeed. And we always ask for material that we never get because they make me file a public disclosure request, which I never get until the whole thing's all over with anyway. So it's my client's word against, them and all of their investigations, which I really never get to see. So I'm sort of arguing in the dark. So I think this case is important for us in the fire service, certainly for firefighters, EMTs, and paramedics, and we'll see what happens. It's going to be fun.
Kurt.
Oh, I'm proud to hang around with you. I'm proud of the work that you did there. I know we kind of, we went through some difficult times there and wrestling and last minute notices and trying to get you brief. And, it was pretty impressive to watch that brain of yours working on it. But I'm glad that it worked out the way that it did. I'm a little apprehensive about where it goes from here because, I had earlier in my career, I had some cases where it was up to the state and they opted not to appeal. And I think their idea was that we'll just isolate this little issue here rather than take a chance and have the Supreme Court spread it around the entire state. And so I think there's probably some consternation going on now about just what they want to do. But I kind of hope you just stay that you won. You won now. You stay that you won. Leave it. But on the other hand, I think for it to have the full impact, it's got to be appealed. So I've kind of got mixed emotions about what's going to happen next. But I'm really proud of what you accomplished, and we'll see where it goes.
And again, you get over the drink credit for the due process idea. But look, I'm not going to let this lie because like I said, I've got 3 other cases. 2 I'm waiting to be certified by the commissioner. Once he does, I'm bringing it up again. One of them might be in front of the same judge. But then I've got a Division of Human Rights decision I'm waiting for. And that's really the one I think is the strongest case, right? Because, they even have an EEOC number. It's a parallel case. I don't see how you get a choice of forum like that. I know these words are a little too much for the viewers, but in any event, thank you. Chip.
Well, I think it's this brilliant argument. It takes a really good tactician to not only find the case and use those facts, but apply them. And then you've already said this. One of the things that everybody will benefit from is a trial judge who is willing to put the time and effort into opinion that can be used everywhere. And we kid about trial judges, and there's some great ones and there's some bad ones, just like in every other stuff. But most of them are not going to spend the amount of time that this particular judge did on this case. And that's why it's, I've told Brad, and I've said here, I've got some similar cases. It may not go anywhere in New York, but it may go someplace in Ohio, and it may go someplace in Washington State, because we're all faced with this. We're going to, in the right circumstances, to continue to use this. And so at some point, it may not be today, may not be next month, may not be next year, but this will make its way through the court systems eventually, and we can use it to our advantage then. But I've told Brad, I can't wait to, I make this demand for us as Department of Public Safety for a jury demand. They look at me like, what, I thought you said you had a law degree. You don't know this. And being able to pass on the opinion of this New York judge that is so detailed and addresses all of the arguments. Like you said, it doesn't apply to New York law. It applies to the states. And when I read that opinion, I was like, this is just unbelievable. And it would rival to me a federal appellate court opinion. It is just that detailed and historical on talking about, Hamilton and everything else. I think it's a great decision.
You think of like Judge Justice Holmes, Posner. I mean, some of the big names, the real big thinkers out there. That's what I thought of when I read the case.
Yeah, and it was actually, again, you don't get to read many cases that are from a lawyer's perspective enjoyable to read. And this, just given the whole thing, I found myself saying this is an amazing opinion. So I'm looking forward to utilizing this. I know I have a client that was excited. I sent him the opinion the day it came out. He's like, "Can we use this? Can we use this?" Absolutely, and we intend to. So, again, for me, it's going to be working through the tactics now. And, Brad and I are, sharing his experience. We all benefit from that. At what point, where do we raise it? Do I raise it right now? I got, the notice of the hearing. Do we demand a jury? Do we make a jury demand now? If it, in Brad's case, we didn't kind of get into this, but they denied the jury demand. And that's when he appealed it to the court, to the trial court. So that may be the same tack that I take. And again, it's already been, gone down that road. So, we'll see where things go. But I'm excited. I think it's going to provide all of our clients an additional tool in the toolbox to address hearings when things may not otherwise be fair. So, thank you.
Well, I couldn't have said anything better than anyone else, but I will repeat it again. Every one of my successes and every one of yours, well, I don't know about every one of yours, but every one of my successes is in some way from one of the three of you, because we all talk about something, somewhere, somehow, and bouncing everything off. And, I've become so much of a better lawyer for being with you guys. But that is the end of our show. I want to thank everybody. Hopefully this wasn't too much over everyone's head and that people could see how, the four of us really are out fighting for firefighters, paramedics, if by no other way showing you what not to do, sometimes defending you for what we hope you hadn't done, but nonetheless making sure that you have your day in court, as the title here now says. So on behalf of John, Kurt, Chip, and myself, the fire service, fire engineering, fire service attorneys, we thank all of you for listening, and we hope to see you next month.
This podcast is brought to you by Firehouse Subs, the firefighter-founded hot sub chain with a passion for hearty and flavorful food, heartfelt service, and public safety. Ready for your next mission? Firehouse Subs is offering firefighters the opportunity to continue serving after service, now as restaurant owners. Learn more at firehousesubsfranchising.com.